With regard to the agenda item on absolute auctions, I know Ms. Jacobs has some pretty strong sentiments in that regard, and I would echo her sentiments. If you're talking about what I'll term, for lack of a better word, fake absolute auctions, a situation where it's being advertised that it's going to sell to the highest bidder, and in reality it's not. I think that practice is reprehensible. I think it was more commonplace sometime back. I don't know to the degree that it exists now, but if that's where this is going, I would be wholeheartedly supportive of that. I will say that if we're talking about the technical definition of an absolute auction, I know Mr. Henderson expressed concerns before about this definition about the hammer falls, that means title transfers. I don't agree with that assessment, and he made the point that even on movables, he couldn't tell you the number of times he had been stiffed that they didn't pay. And I'm going to state 4 instances that I hope the board is going to look, or when we're talking about this, I hope the board is going to look beyond just is there a mortgage or not, because it's just not that simple. I'm going to cite 4 instances where an absolute auction, in my opinion, is certainly appropriate. Number 1 is when the auctioneer holds the mortgage. I conducted an auction last year. I'm sure Ms. Dow researched it. I hold the mortgage. I have the prerogative to accept whatever I would like. I should not be prohibited from advertising an auction absolute under those circumstances. Number 2 is when the creditor gives written authorization for the auction to be absolute, and it can be proven by the auctioneer providing that written authorization. Number 3, if the seller readily demonstrates an ability to cure any deficiency. Perhaps the seller has liquid funds that totals the entire mortgage. I don't think it would be correct to try to inhibit an auctioneer from advertising an auction absolute under that scenario. And 4th, in a bankruptcy auction, which is all a matter of public record, and it's been clearly disclosed that the creditor can credit bid up to the amount of their mortgage, and that is disclosed in the public record. And in essence, what is happening is the bankruptcy judge is utilizing the auctioneer to bypass the sheriff. And I know that was done a couple of times in the last year. Marvin Henderson had a couple of auctions pertaining to the Sammy's restaurant that got constructed down around Prairieville. In my opinion, he should have been allowed to advertise an auction absolute. I think he opted not to. He probably did so maybe because of some concerns in that regard. In my opinion, those 4 instances, it is certainly appropriate for an auctioneer to be able to offer an auction absolute. 7 seconds to spare.
We'll take up Anna. Absolute auctions.
And the reason I've asked the board to review this is we had a complaint filed by a mortgage holder whose property went to sale at an absolute auction. The mortgage holder was very upset. He did not give permission for this item to be sold at an absolute auction. It sold for less than mortgage, but they just simply rescinded a sale from an absolute auction, which resulted in the sale being no good. The item was returned to the mortgage holder, and at this point he's not much he can do with it. So his request was for this board to have a hearing, but we don't have a lot of information with regard to how we handle absolute auctions. We did pass a regulation some time ago that is very short and to the point, which simply says that a sale by an absolute auction is simply a sale that must change hands. It specifically states that changes ownership regardless of price. That's section 1706 of chapter 17, of our regulations. So
That's the only thing we have.
that's the only thing we have right now. The problem we have is, and this is not for whether the sale is absolute or not, it's the advertising of the sale. If you advertise a sale as absolute, the question becomes, what can be sold at that particular auction? Can items with a mortgage be sold? Because you understand that if you sell a mortgage, this isn't talking about judicial sales, it's not talking about bankruptcy sales. In those cases, the earlier mortgage or whatever lien there may be on the item is canceled as a result of the sale. These are sales by auction which are done as private sales with regard to real estate or movable items. And when you do that, you transfer. I'm looking at a report here as an example. An auction is advertised, they sell a washer and dryer that's worth $1,500, the highest bid is $35. Then it has to sell for $35. Some states take the position that if you have a mortgage on a property, it is automatically has a reserve on it. So because you have to pay off that mortgage in any effect. If that is the case, then it cannot be advertised as absolute.
Because an absolute auction cannot have a reserve.
It's absolute subject to the mortgage.
No,
it's
sir.
not absolute. Absolute means without limit and reserve. And before you can advertise something as absolute, you would have to have, if it's mortgage, you would have to have something in writing
Right.
from the creditor that they are allowing you to go forward with
That's
the
right.
auction and will accept whatever they have. Come on, that's the law. That's Louisiana law.
Yeah, and basically some states have, state boards have enacted rules that simply say you can't advertise it as absolute if there are liens or encumbrances on the real or personal property unless the mortgage holder has given consent.
And it's gotta be written consent.
Written consent. Some states just say you can't do it. If it's got a mortgage that you're aware of, and be aware that we've had at least one case that came out some years ago, I'm looking for, that involved Johnny Gwynn, as a matter of fact. That basically says the auctioneer has a responsibility to determine if it's a public mortgage, if it's publicly recorded, you have the requirement to at least try to find out if there's a mortgage on the property. That is your duty. So if you find out that there's a mortgage, the issues that have been presented in these other states are simply that, are you starting the bid at the mortgage amount so that you can make sure you cover the mortgage? And if you're doing it that way, have you set a minimum bid, and is that something you can do in an absolute auction? And they have regulated that now.
It is.
Okay.
Is this all regarding the Joe Wilson sale on Toledo Bend?
No, actually, this has to do with absolute auctions and what the board's position on it is.
I'm asking for
That's the mortgage holder, that was a sale of an RV at an absolute, an auction that was advertised as absolute. That it had a huge mortgage of, I think, $250,000 on the RV, which is more than its value. It was sold for nowhere near that amount. Yeah, and as a result, the mortgage holder, who was not notified that it was selling at absolute auction, was the one who filed the complaint because he was not protected in that sale. That the purchaser would not have been protected in the sale had the sale was rescinded. The purchaser would not have been protected in the sale, he would have owed the entire mortgage, as I understand it, or at least to the value of that RV.
question regarding the Morgan Joel. Said he did not know anything about it, being so. Is that what you said?
You mean the mortgagee?
Mortgagee?
No, he said he found out immediately before the sale. And he advised them there was a mortgage on it, and he did not consent to it. He sold at absolute auction, and it was.
Well, first off, Louisiana was no such animal in that.
I'll go
Never
back
had
to
it in years. Only under certain circumstances, Robert Burns described Margot the best way to describe it. Those are exempt and can be done. But it's to my knowledge, the law is clear. There's no absolute auctions in Louisiana. Period.
Well, then you ought to look at the RTC auctions that occurred 10 years ago. Almost all of them were absolute, and I bought some of that real estate.
Wait a minute, dog. I mean, wait a minute. That's all federal court order.
Well, but it's
That's
not,
a
if
court
our
order.
Louisiana auctioneers holding absolute auctions, and Gilmore advertises them all the time.
I know.
Absolute, I'll cut it out and give it to
Hey,
you.
I know.
You know, you're getting into a real fine line here,
And I know,
because
but it's-
some of you all may be brokers, and if you are a real estate broker and an auctioneer, you know that as a real estate broker, the thing that you have to do before you sell a piece of property is to make sure it's not encumbered in order to protect the public. As auctioneers, we don't have to do that. And that's a real fine line there, and I gotta tell you, that, you know, if you advertise something that's absolute, I can tell you in any court of law, if you do not have a waiver from the mortgage holder in writing, it is not a good option. In any court of law in the state of Louisiana.
Right, that's why we need to adjust this.
Well, that's my question. I have two
See,
questions.
you're dealing with two animals. You're dealing with a movable and an immovable. And what what Donald says is correct. I know it. When I sell real estate, I have my attorneys do the due diligence. We know everybody that's owed or whatever owed. And like she said, they came in here and they did this, they got by with it because it's federal court order through the FDIC or FSLIC.
But Gilmore has them even if it's not an RTC. He does it all the time. A lot of his auctions are absolute. Just take a look at the Sunday newspaper and he advertises them. You can
And I agree
you can
with
have an absolute auction because they check it out and make sure that the property is not mortgaged.
Correct.
And if it's not mortgaged, then you can have an absolute auction. But if you've got someone encumbering that property, whether it be immovable or even movable, because a bank could have a mortgage on movables, and I'm sure Tesla will tell you that's what she specializes in. You cannot auction that off as an absolute auction without protecting the mortgage holder. Their rights are paramount in the state of Louisiana.
I mean, I don't say anything, we gotta, we check, we do a lot of work for banks, we check, if we got a list of items that they've got mortgage, we run the UCCs and the whole 9 yards.
And a lot of auctioneers don't know how to do that, whereas real estate brokers do, because we're trained to do it. Well, then you're getting into an educational situation with the average auctioneer who may not be qualified to hold some of these auctions that are absolute involving real property and immovable property.
Is this gonna require legislative action?
No, the board decides and can determine what an absolute auction is. I've just read you our definition, which is very short.
Right, we were seeing if it needed to.
And I think that an absolute auction should be defined as any property which is not encumbered. Or if it is encumbered, that there is a release from the mortgage holder to go forward with the absolute auction so that a seller can be able to take possession of the real estate or movables that he has purchased without someone stopping them from saying there's a mortgage on it and declaring it null and void.
First question I got, and this is Diana. Did this, mortgage holder, do they have more than one piece of property in this auction?
No, they
This is
just,
the only piece they have?
that's just the only piece they have.
Is
So
this a
then,
Louisiana lender or a Texas lender?
it's a Louisiana.
The reason I'm being so critical on this is because this sale was advertised out of Texas. This was a second rider day auction that went with that auction.
And I'm not trying to get into the details of the auction, I'm just trying to
All I'm trying to do is
determine.
tell everybody what the deal is. But, I got to agree with Dawn to a point. But to a point, I don't want to get this loss of doggone rigid that everybody in the state gets in trouble.
Well, no, I'm just,
And
what
then
I'm.
I go catching the devil about it, because I done got a bunch of calls about it.
Okay, there's nothing worse to someone, they do it in Mississippi. This is another problem that I have with the state of Mississippi, where they advertise something as being absolute, then they call people up and say, well, how much were you planning on bidding? How much are you planning on bidding? And if they don't have what they think they're gonna need, they call it off the day of the auction. They do that, and I've been to,
I don't agree with doing that.
well, they do that, and I've been to auctions in Mississippi where they advertise it as absolute, and then they say, oh, guess what, the mortgage holder isn't gonna accept your bid. I went to one of those around three months ago.
That is not an absolute auction. it's
Well,
not.
but it was advertised as one.
And I guess the only way you could do this would be write it out, you just have to write regulation into our, whatever we do.
Well, that's what I'm trying to do.
I understand, Justin, but what I'm trying to get worded
Right.
where it don't tear somebody's head off. It's just simply, it's gonna be like a one sentence deed.
Then they have an obligation to the
They have an
public to check it
obligation,
out.
and all you've got to do is, number one, if it's title property, it's gotta be run through the clerk of court, and the clerk will certify to you whether it's got a mortgage or not.
Well,
Then, if it's a movable piece of equipment, then you run it through the UCC, and the Secretary of State's office, if it's got a mortgage, you'll sign it.
And if,
I don't know outside of that what you could do. I'm
Well,
not gonna sit here and tie the auctioneer's hands, I'm not gonna vote to do it. I'll do it under those two circumstances.
that's already the law. I
I
mean,
understand that.
that is already required. The question is whether, once you have done that and you advertise it as absolute, what is the board's position?
I don't
Should
think
we-
it ought to be advertised, I don't think there ought to be anything advertised absolute unless it's tied to a sheriff's sale, a bankruptcy sale, etc. I don't think it ought to be. I think it ought to be advertised straight out as an auction sale.
So,
Well, I would disagree with that.
Right.
Because
Because they don't
as
have
someone
any
who
reserves.
frequents auctions in my company, we bid in all the time, at auctions, I mean, I'm gonna really look, if something's absolute, and I'm really interested in that property, I'm gonna have my bidders there to go bid it in, whereas if this says it's an auction, it might be incumbent $300,000 or $400,000, which may be more than its value, and I may not even wanna attend.
Right, but if it says absolute, it has to.
Right, I mean, I think I have a fair
Without
chance,
reserve.
exactly, absolute,
Or
without
more.
limit or reserve. If it
Right,
says
without
that,
limit or reserve, yeah.
I think it should be advertised to the public that
So,
way.
what is the board's position? Do you want me to write our draft regulation for review at the next meeting?
I would like that, yeah, I would like that.
Is that the general consensus?
You don't like that, Jim?
He
I don't
doesn't
have a
really
problem
think
with
should
it.
be.
The problem I got with it is this,
What?
and it has been this way, I don't know how long they've been doing it. The first thing I was told when I went to auction school in 1974, there's no such animal as an absolute auction. And every auction school I know of in the country has taught that way since I went, and therefore, she's in the real estate business, it's a little different
Right.
twist that. I know they do things different. That's why you use a real estate, most auctioneers that don't have a real estate broker's license, they use a licensed
Right.
broker with their dealer
Absolutely.
and their attorneys. And my attorneys and my brokers, we're going to the bank, we're going to where. The problem I got is when you go to tying people's hands how they can do things. And I disagree with Carla about absolute. I'm not gonna advertise that absolute. I had never done it.
Right.
And
But
if
a lot of
y'all
people-
want to go
yeah.
there and Gilmore wants to do it, fine, I'm not.
And a lot of people do, but I think they,
If David Gilmore's doing it, he's the only one in the state I know of that's doing it.
I'm gonna cut out his next advertisement, because he has
You
them
ain't got
almost
to
every
cut out
weekend,
on
you
him.
know he does
I
it,
got
you
a
know
good
it.
idea what
there's
goes on.
several people. that
Well,
are
I've
doing it.
advertised some on this being absolute on the
Right,
ones that
several
we've done.
people are doing
Right.
absolute.
But if it is, the only place I know it's being done is in your area.
It may be.
It's not being done up
Maybe.
north. It's
Yeah,
not being
maybe.
done up there.
Jim, let me ask you this. Do you want me just to eliminate, say you cannot call an auction absolute?
That's what I think ought to be done. It
I'd
ought
be-
to be
I'd
out-
be
it ought to be
against that.
ruled out, period.
And I
can't
think
do it.
I think you're inviting a lot of litigation.
But
Yes, you
unless
are.
it's under what they
Yeah.
want.
Unless it's under a judicial order. But when you go under a judicial order, then you take the whole sales proceeds from everything and put it into one pot. Then you pay off all encumbrances. And then if it's a piece of real estate involved in it, then if you got a bankruptcy trustee or a sheriff involved in it, then it's a different animal. You gotta go through the courts and get court orders to do various things.
Well, if it's a sheriff's auction, well, number one, sheriffs are not auctioneers, as you know. People at auction, most of them are not, that auction for the sheriff. They're gonna go in there, and if a mortgage holder isn't there to bid in his own property, he loses.
That's right.
That's right.
That's right.
We have one of our gentlemen out in the audience has been
Thank you for
anxiously
recognizing me.
raising his hand, so, Madam Chairman, do you
Yeah, you
recognize?
missed the public comment, Freddie, so go ahead if you want to make a comment.
Well, no, the issue seems to be more so with limited technicalities to absolute and procedures. I mean, those who know what to do, they're doing it. And those who don't need to be educated, but I don't think it's where
Well,
they're.
But the problem you have is that you've got auctioneers handling immovable property, and they don't have the training to do it to be able to go out there. So the question is, do you have another category, or does the legislature establish another category of auctioneers who actually are also real estate brokers? I can't answer that question
Well, I
as to
mean,
whether or not they want to do it, because that's a burden on some of these people that have been auctioning for years and do it correctly.
but would that would be simple just to send out a memo to all the auctioneers per se, informing them of a procedural guideline or something, educating them concerning that, which will eliminate that problem so that they'll know.
But they have to have training to be able to go down there and run a title check and.
Well, no, I mean,
or
they
hire
may not
someone
do
to
it, but they may get a licensed broker or someone to do it for them. I mean,
Well-
it's just the fact that they need to know the procedure.
I don't think that this board can actually enact procedure without having their attorneys advise them, so I will not advocate that without having our attorneys actually give us some guidelines on that, because I'm not sure we can do that. I think that might be something for the legislature to consider, and I would think that if you do make auctioneers who auction immovable property, if you say they also have to be a real estate broker, you're gonna get a lot of opposition
Correct.
from those auctioneers who are already grandfathered in and who already do it. So I wouldn't want to be the one that would, insist on that.
Jim,
I
you have a
wasn't
comment?
suggesting that,
Wait
Miss-
1 second, Jim.
The
Had a
comment
comment
I
to
got,
raise
I'm not gonna
his
sit here
hand
and
for
vote on anything that's gonna restrict a licensed auctioneer in this state from crying whatever he wants to cry. Whether
I
it be
agree with
real estate or whatever. And I'm afraid if we go get into this absolute deal, we're gonna wind up over in the legislature, having to get something done, and somebody's gonna slip something in over there, a midnight deal, that we're not gonna know nothing about, and it's gonna get through.
Well, I thought, Jim, you didn't want to be able to advertise anything as absolute except for,
I don't,
So
but
I'm
I don't
confused.
want, but on the other hand, I don't want to get in there either where if you gotta be a licensed broker in Louisiana to cry real estate, I don't want that either.
And I think a lot of people already grandfathered in and they're doing it correctly. I think you're 100% correct on that.
But if
I
you have an
understand,
auction-
I understand what you're talking about, but somewhere down the line, anybody that's been to auction school knows what they got to do.
right, I understand that. However, if you have an auction without any reserves and you're selling it, it's going to be sold, not without a mortgage or anything. You can advertise it as absolute, and a lot of people would like to continue to do that. And I don't think we can stop that by saying, well, no one can use the term absolute. However, I think we just need to define our term. So you are gonna come up
I'll
with,
Come up with something.
draft,
that I bring
and
to
I've looked at other states and how they're
Right.
handling this issue, and I'll bring you some suggestions from other states so that we can sort of look at it. Now, be aware, this is not just immovable property.
right.
We have this issue more often with vehicles than we have with real estate, where
Correct.
people have complained, they bought a vehicle at absolute auction, that there was a mortgage on it, they can't get the title, and now it's tied up, and that's when we get complaints on that too. So we're not just restricting this to real estate, it is an issue for both. My second question, that was actually just my first question, my second question to the board is, I do have this complaint, I wasn't gonna mention any names, but, that I don't know whether the board wants to hear it because of the discussion as to whether or not what absolute really means to the state of Louisiana. Because this was a mortgage holder filing the complaint, not the buyer. And the question is this something that you want to have heard at hearing?
I would rather the legal team give us their definitions of what an absolute is. To me, an absolute auction is an auction without limit of reserve. And that is the way I've been trained, and that's the way I've operated for many, many years.
So, Bob,
But,
Now, if there's another definition about it, I don't know.
well, the question is, what is the duty of the auctioneer to the mortgage holder?
No, I think it's a duty of the auctioneer. You've got to make sure that before you auction something off for the public and tell the public, come on over here, I'm having an auction, that you have something free and clear of encumbrances. Or else it's fraud, in my opinion.
When he signs.
And I think it's actionable as fraud.
For example, when they sign their auction contract, if it's a state that's got vehicles, whatever, with real estate, vehicles, movable, immovable property, everything, all titles are delivered to me when they sign. If they don't have a title, that tells me, number one, that immovable is
It's
more.
encumbered.
Okay.
If they don't give me a bill of sale on that real estate that's notarized by an attorney, that tells me it's got a mortgage on the real estate. I go to my attorneys, I turn everything over to the attorneys. We find out who the lender is, we go see the lender. And 9 times out of 10, they will sign off on it. For you sell it.
With the
But we
understanding,
have a reserve. It's got to meet 85%. My contract is
See,
what,
then it's not without limit of reserve, it's not absolute, so you
I
said.
don't advertise it.
Yeah.
right.
I'm just telling you the way we do it, and, you know. we don't
what,
have
I'm gonna go
problem.
ahead, I think from what he's saying, that we need to go ahead and set the hearing.
Okay.
Because it's a factual
How you
issue.
gonna set a hearing when you ain't got a regulation to cover it?
You just said what your position is now, and that's what I understood.
Well,
And what you and Darlene are talking about with
right,
regard to
I mean,
that.
I thought you were gonna come out in September with something wrong with it.
Well, that was my first question. My second question is, what's the position of the board today? Is it something that should be set for hearing?
I think it should be.
How many people we gotta drag in here from out of state?
Well,
I'm not dragging anybody. They
I
can
think
file
Anna,
applications.
Anna's an officer of the court. If she tells us what the law is, I'm going to accept that because she's an
I
officer of
understand,
the
that's
court.
what I'm asking you. I'll tell you one-on-one later, and Anna already knows.
Well, yeah.
The thing is, You know, there's two people involved, one person involved in this is bigger.
Let her say something,
Let's
please.
remember ex parte conversations regarding pending complaints. You know, I would counsel the board again that you not have conversation regarding pending complaints with anyone, because you know, you are going to hear this as a neutral party, and the statute provides, the APA provides, that you cannot discuss any pending complaint with anybody outside the board prior to the hearing. Everyone understands that. That has been the law for a long time, and I think we've had discussions about that.
Well, you know, I got, never mind. Let's move on. Well, I got a problem with that.
Well, can Anna,
Wait,
you're gonna be able to research
One at a
it,
time,
right?
guys.
Okay, yeah, okay.
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 All right, but anyway, that's my conversation regarding absolute auction. If you have any, you know, want to talk to me about the auction itself, that's fine. With regard to the other, I'll go ahead and see if we can set
Let me
that.
just bring up a point. Tessa, you auction on a regular basis very valuable articles
Yes.
that people give you on consignment.
Correct.
Before you take those articles, don't you make sure that they're not encumbered? Because you're actually
Absolutely.
going on the internet, you're sending out these wonderful brochures that you all do, and you've got high-profile people bidding thousands of dollars on this.
We do.
And that's part of your job, isn't it?
It is. And we have never advertised absolute. But we don't have.
But you
absolute.
check it out, you make sure.
Oh, absolutely.
All
We
right.
have to, because I can't sell it without a clear title. And I have contracts stating that. Okay, Freddie, let me just make one point here. We now do the public comment on agenda items, you know, set it on the agenda for 5 minutes so that we can kind of keep the meetings rolling. But if you want to make a brief comment since you missed it, please go ahead.
Well, I thought
Just in the
she was-
future.
Yes, ma'am.
next
I'm
meeting,
not-
That's how we're going to work.
Yes. She recognized me, so that's why she asked the
And I
question.
just wanted to make a point on how we're
I
doing it
understand the
now to
procedures.
keep the.
Here's what I was suggesting, not so much as to legislate anything else like that. The communication to the auctioneer's base is just information of education that they can follow. I mean, I have a question to ask on my contract, is any of this mortgage, any debt, anything on it, and I check off and they'll issue it. So that they can say that when I ask the question, they follow through the guidelines. Very simple procedure, but you know, if we can educate the auctioneer's base without being incumbent upon legislation and putting a lot of pressure on both sides of the table, because you got the broker side, which are on both sides, and the auctioneer side. So I'm gonna side with, you know, the auctioneer should do that, but I understand what the broker side means as well. So what I'm suggesting is, if we send a communication out to the auctioneer's base, just information, just to give them some procedural guidelines, not a law, something that they should look at or could consider. It'll educate them. We don't have continuing education, so we're at a disadvantage there that we can put this into some type of practice.
Except a lot of people will say something's not mortgaged when in fact it is, because they need to go forward with an act of sale. And the person that really suffers for that is the general public, and I have a problem with that.
But if you ask the question and they sign off on
Well,
it.
my experience is that some people are just not truthful with it. I think an auctioneer has a duty to go ahead and investigate it. And the question is, are they capable of doing that? Are they capable of running a title, such as a real estate broker would be before they accept property for sale?
Okay. So we're clear on this? We know you're gonna-
Can-
I'm going to do both,
Okay.
both for next meeting.
Can I?
Thank you,
No,
Robert.
but I think we have
Can I-
another question.
Well, and I already addressed it, I hadn't heard anybody mention it, but, you know, if someone has the liquidity and it's backed by a bank statement, they may have enough cash to cover the
Well,
mortgage.
absolutely.
Well, and so I'm asking, is that gonna be incorporated in? If the bank says we'll freeze the account or we'll pledge the CD to it, you know?
This is only with regard to advertising it as absolute, not whether or not is transaction correct.
Well, yes, but if they have a mortgage, then there may be some issue about whether or not you can or cannot advertise it absolute, and that's what I'm going to. In my opinion, in that situation, you should be able to advertise it
Well, yeah,
absolute.
It's not in,
I'm
we're
gonna-
gonna waive that, absolutely.
Most
We're
of
on the
the-
same page with that.
Okay,
And most of the states have a regulation that says if the mortgage holder consents to do so, then.
yeah, but the mortgage holder may not be consenting in this case, but nevertheless, the owner says, look,
It's,
I got a CD with this bank, I have a demand deposit account with this amount, and I'm even willing to freeze to where it can't be withdrawn before the auction. Might even not be, the bank that has the demand deposit account may not even be the same bank that holds the mortgage. And I think, given those circumstances, They certainly, and I think you talked about being actionable a while ago. I think the board has to be very careful about tying someone's hands about advertising absolute in that situation. The word absolute is electric. We all know that, you know. And I can tell you right now, not every auction school says you can't conduct an absolute auction, James. I can tell you that Continental Auction School will tell you, if you can, you better. Because it is an electrifying word that brings out bidders and maximizes the result. And that's the only reason anybody would fight over whether or not you could use the word absolute.
So we're going to get clear language on that for the next meeting?
Yes.
Okay.
Thank you.
Thank you all. All right, so, that's, so, our next meeting date is September.
Wait,